Good afternoon, or morning, or evening, whenever you're listening to this. It's afternoon when I'm recording it. I want to cover legal defenses and juvenile justice today. So, legal defenses include if the accused acted under duress, if the accused was underage, if the accused was insane, if the accused acted in self-defense or defense of a third party, if the defense acted or if the accused was entrapped or acted out of necessity. The first defense we'll talk about is acted under duress. One of the most famous cases where this defense was used was the case of Patty Hearst. She is the American newspaper heiress. Her grandfather was William Randolph Hearst. In 1974, she was kidnapped by the Symbionese Liberation Army. The SLM was an American self-styled left-wing revolutionary group active between 1973 and 1975. They committed bank robberies and 2 murders. The group demanded that her family distributed $7 million worth of food for every $70 worth of food for every poor person in California. This would have cost the Hearsts over $400 million. They eventually donated $6 million to the poor in the Bay Area. The SLM said that the food was of poor quality and they refused to release Patty. She joined the SLM and was arrested during a bank robbery. In her defense, several doctors agreed that she was under duress. Specifically, she had Stockholm Syndrome, which, as you know, means that due to brainwashing and mind control, she identified with her captors. She was found guilty and sentenced to 35 years imprisonment. However, after serving 2 years in prison, Jimmy Carter commuted her sentence. She was granted a full pardon by President Bill Clinton in 2001. The next defense is called defense of infancy. Children who are under a certain age are excluded from criminal liability for their actions because they can't fully appreciate the nature of their actions. There's a fair amount of controversy around this. The prosecutor must prove that the child did not know what he or she was doing at the time of the crime. The age at which this defense can no longer be used varies by each state. The minimum age is 6 in North Carolina. 13 in other states have set minimum ages that range from 6 to 12. The states that don't have a legal age rely on common law, which is 7 years old. The federal age is 11, and after that, children can no longer use the defense of infancy. This is similar to the insanity defense because there's no mens rea in either case. Basically, in insanity defense, the accused does not know what he or she was doing at the time of the crime. I think this is pretty interesting, so I'll tell you the history of the insanity plea. The case of William Freeman in 1846 was perhaps the first example of a plea of insanity in the United States. William H. Seward defended Freeman when no one wanted to defend him. They wanted to lynch him. Freeman had been released from prison for stealing a horse when he committed a murder at a farmhouse in Fleming, New York. He first stabbed the wife, then the husband, and then their 2-year-old son. Freeman was then attacked by the victim's mother, wounding him on the wrist. He stole the family's horse and was arrested at 2 a.m. the next morning. At the trial, it came out that Freeman had been flogged for not doing a full quota of work. He rebelled and hit the guard, who then hit Freeman with a piece of wood hard enough to break the wood. Then he hit Freeman another 10 times, and then once Freeman was overpowered, he was flogged twice the usual number of blows. A consultant from Ithaca, New York Lunatic Asylum, that's what it was called, testified that the brain was an organ of the mind and could be affected by psychological and physical causes, which could lead to mental illness as well as bodily dysfunction. Seward proposed that Freeman was insane at the time of the crime. What do you think? The jury found him guilty and he was summarily executed. A few years later, Seward, the attorney in the Freeman case, was involved in another case. It was during the Civil War, and a white physician was accused of killing a black lieutenant, Allison Sanborn. Sanborn, a school teacher from Vermont, was drilling a regiment of black volunteers on Norfolk, Virginia's Main Street. The physician became incensed at former slaves jostling men and women and children off the sidewalk. In fact, he was so overwrought that he fired 2 shots, killing Sanborn. The physician was tried in a military commission established for the trial. The jury found the physician guilty. The physician's lawyers appealed to President Lincoln to suspend the execution until the case could be further examined. The defense said that the physician was insane at the time of the shooting. Because Seward was a friend of Lincoln's, he was called in as an expert witness. This case wasn't only about insane or not, it was political. Lincoln was concerned about the fragile Union being torn apart. There were those who urged for black soldiers being given equal pay, equal promotion, and prisoner of war status if captured. Lincoln agreed. However, in retaliation, the Confederate Congress passed a resolution ordering white commissioned officers to be put to death if they trained black soldiers. Lincoln's military leaders advised that the physician must be hanged to preserve morale and discipline and preserve the Union. The public tension was at a dangerous level. Lincoln had the choice of 2 experts in insanity and chose the one that he knew would testify against insanity. To preserve the Union, the physician was executed. Here's an early example of the carrying out of the law being influenced by political expediency. Americans' laws about insanity came from England's laws. The first test for insanity was called the wild beast test. In 1724, a peasant killed a nobleman who he believed had bewitched him. The judge in the case said if the defendant was totally deprived of his understanding and memory, that he did not know what he was doing, any more than an infant, a brute, or a wild beast, he could not be held accountable for his crime. The next test in England was called the Macnaghten test. Macnaghten, a woodcutter, shot and killed Edward Drummond, mistaking him for Sir Robert Peel, the Prime Minister. Remember Sir Robert Peel and the Bobbies? He thought Sir Robert Peel had caused all of his problem, and witnesses during the trial testified that Macnaghten's behaviors were odd, and medical experts said he had delusions that deprived him of normal restraint. The case was then sent to the House of Lords, and they ruled that there were 2 premises that could determine insanity. 1, it must be clearly proved that at the time of the crime, the accused had a defect of reasoning due to a diseased mind that prevented him from knowing what he was doing was wrong. And 2, it must be proved that at the time of the act, the accused did not know the difference between right and wrong. Later in England, the police at the elbow test was used. If the impulse was so strong that the accused would do the deed, even if there was a policeman at his elbow, he must be insane. The U.S. courts used the Macnaghten rule until 1955, when the Durham rule, also called the product rule, was used. This came about through the introduction of psychiatrists into the courtroom as expert witnesses. This rule said that an accused is not criminally responsible if his unlawful act was a product of a mental disease or defect. This changed when John Hinckley Jr. was determined to be insane when he tried to assassinate President Reagan. Hinckley was obsessed with Jodie Foster and thought that killing the president would impress her. Duh. The new test became the defendant as a result of severe mental disease or defect, being unable to appreciate the nature and quality of the wrongfulness of his act, could be determined to be insane. More recently, there was a case in Virginia of a man charged with killing his parents because he believed he was living in the virtual reality of the movie, The Matrix. Another man in San Francisco chopped up his landlord and claimed he had been sucked into the Matrix. Fortunately, juries have rejected these as bona fide insanity defenses. Currently, some states still use the variations of the McNaughton rule, and others use guilty but mentally ill. This allows the defendant to be convicted and given a criminal sentence. Now, genetic evidence, MRIs, and CAT scans are being introduced into evidence in insanity plea trials. The insanity defense is used approximately 1% of all felony cases that are brought to trial. And about a fourth of those are successful, yet the topic remains of great legal importance. Most people think the insanity defense is a get out of jail free, but in fact, most people who have successfully used it go to state institutions for the criminally insane with no release date. The date these individuals are released is dependent on mental health evaluations and usually no longer sentences than if they had simply been determined guilty and accepted the standard sanction. On the other side of the coin, if the individual is really insane, putting him or her into prisons with the general population would be inhumane because they would quickly become victims of abuse. The last three defenses are self-defense, entrapment, and acted out of necessity. Self-defense is usually claimed in crimes of violence, such as battery or assault with a deadly weapon or murder. The defendant admits that he committed the crime, but claims that it was justified because of the other person's actions. There are three core issues that generally play into this defense. Who was the aggressor? If the aggressor was much smaller or weaker than the defendant, then this defense might not work unless there was a weapon involved. Two, was the defendant's belief that self-defense was necessary, a reasonable one. The recent case, actually not so recent now, of Zimmerman versus Trayvon Martin is a perfect example of this. When Zimmerman shot Trayvon, did he believe that Trayvon had a gun, for example? The Stand Your Ground legislation of 2005, which was championed by the National Rifle Association lobbyist Marion Hammer. In support of the law, Hammer said, "Through time in this country, what I like to call bleeding heart criminal coddlers want you to give a criminal an even break, so that when you're attacked, you're supposed to turn around and run, rather than standing your ground and protecting yourself and your family and your property." But critics in Florida's legal community dubbed it the shoot first law. And said it encourages people to stand their ground when they could just as easily walk away. It was also pointed out that the law gives citizens more rights to use deadly force than we give police officers, with less review. A report by the South Florida Sun-Sentinel responded to these complaints, concluding that several accused murderers have successfully used the Stand Your Ground law to prove they were victims. The next defense is entrapment, and I am going to end this slide section and go on to the next because I'll run out of time and the slideshow will close. Okay.